We can have an advocate if there's an advocate representing the family of the deceased. The rest of the people, let them exit. Yes, give way to the OCS people, and don't make problems for the OCS. Let's have a confirmation from police that there's a vehicle outside waiting and that the civilians are far away so that the suspect is not pulled and pushed in the process. Okay, you can have him go, but ensure that there's no pulling and pushing around. And Michael, please do not try to flee from the police. Do not try to give them problems because we are protecting you. Make work easy for all of us. If you try some tricks, we have to do now. So let's meet at 1 day.
Ini ya nani? Ini ako. For the detention continuing or to be released. So far, no charge has been brought. No information has been filed. When you go to jail, to be released on bond or bail, on reasonable conditions, pending a charge or trial, unless there are compelling reasons not to be released. We have not been given one, Your Honor, one compelling reason to keep Michael, Juma, or Yoma in custody. And here we are sitting, Your Honor, continuing to derogate and refuse to obey our Constitution. When you look at Article 2 of that Constitution, Your Honor, it proclaims that it is the supreme law of the Republic and binds all persons and all state organs at both levels of government. This court, Your Honor, is a state organ. Yes, Your Honor, I'm just about to wind up. Article 3, Your Honor, enjoins every person in this republic to respect, uphold, and defend this Constitution. That, Your Honor, includes this office, this court. I am very uncomfortable that this court is being asked to continue keeping my client in custody, yet it may not have the jurisdiction to make that order. The only order, Your Honor, that this court commends itself to make is to reject the application by the state and restore the liberty of the subject Michael Juma Oyoma. I rest, Your Honor.
Yes, Your Honor, I fully agree with my two learned colleagues and their submissions. Your Honor, I only wish to add that we were before you on the 5th of September 2018. And order number 1, which Your Honor gave, was to the effect that the state is granted 3 working days, being 5th, 6th, 7th September 2018, to conduct investigations and draw up charges, if any. So, Your Honor, what we were ready for today as the defense on behalf of the suspect was if charges have been drawn. You know, nowhere in this order was it stated that this Honorable Court was to revisit the application. Your Honor, this Honorable Court cannot sit on an appeal on its own orders. But instead, what Your Honor is being treated to is a fresh application on an application that has already been argued and a ruling rendered. Your Honor, that is not law. There is no single affidavit filed before this Honorable Court to state why this application is being revisited. Your Honor, on that particular day, I remember you having asked the then investigating officer, Mr. Hassan, who is here in court, as to the time he requires to finalize and bring the charges. And he said 3 hours. He's here in court. He said 3 hours. You know, we don't know what transpired between then and now that the prosecution now wants 10 days. Your Honor, what has downloading of phone messages, call logs to do with the custody of the accused person? Nothing. They don't need him to download all those things they want to. They don't need him to process the DNA results, which they have illegally taken from the suspect. Your Honor, what the prosecution is doing, they are merely dragging Your Honor into their investigations. They want you to be part of it. By granting them more time so that they can continue abusing the suspect's rights. And we plead with Your Honor not to take their invitation. Most of life. Your Honor, the suspect remains innocent until proven guilty. There is no amount of theorizing on how this case is a case of great public interest that should allow tramping on his rights. Lastly, yes, Your Honor. You know what I understand counsel for the state to be saying is that they have nothing so far against the suspect. And if that be the case, let the accused be released on whichever terms this honorable court may deem fit. And if that may not be the case, then let the case be taken before a proper court for its trial. We rest our submissions here.
Yes, Your Honor, let me try to respond to all the issues raised. Let me start by saying this. As senior counsel said, the right to liberty of the suspect is at stake. Your Honor, what about the right to life of the deceased? Our submission is, let's not try to rank provisions of the Constitution because they are enshrined in the same document. Your Honor, if I look at the order that you gave, and that is order number 1, I beg to read, clearly says, the state is granted 3 working days, being today 5th, 6th, 7th September 2018, to conduct investigations. So in the first instance, and I believe that was in your own wisdom.
That's what I think we need to refer to what I wrote.
Yes, sure.
The sentence stops at
Yes.
The state shall also benefit shall also benefit from the weekend to complete what will be left. What will be left of their investigations, and thus the state is benefiting 5 days to complete investigations and draw up charges if any.
Fair enough, Your Honor. My point is you gave directives for prosecution to conduct investigations into this matter. And as my learned senior, Councillor Shoya, is trying to insinuate, this process is being conducted with the highest, take it from me, highest integrity possible. And that is why the specialized team of homicide has been brought to the ground to beef up support for investigators who are here. Your Honor, we have, in the process of being lawyers, they have also become experts. and they are talking about the process of DNA not being proper and stuff like that. Our submission is this. During the 3 days that the court gave us, we tried, or rather the investigators tried as much as possible to do what they could. And within those 3 days, amongst other things that they did, they collected DNA from the accused person, which is lawful, after conducting a post-mortem of the late Sharons. Your Honor, we were working with timelines. As I said, counsel again said, the accused person or the suspect hearing is not being subjected to fair trial. What is fairness? Fairness means the accused person being given bond, the accused person being released from lawful custody. That is not the point. We are saying all these people who are in this courtroom, including ourselves, we want to see justice. And as much as they advocate for fairness.
Your Honor, in the course of Mr. Mbani making a response, which is level 2, he cannot go into facts. He addressed the facts. He's assured that dealt with the facts. You have addressed the law. The only area that he can address you on is a matter of law. Whether the taking of DNA samples was lawful or not, that will be another day during the trial. It adds no value whatsoever to these proceedings.
Thank you very much. Your Honor, the same constitution that they are relying upon to quote their own citation, Article 25 of the Constitution, I read, despite any other
A minute.
Yes.
You have 1 minute.
There are several other issues, madam. Give me five. Five, kindly. I'll try.
You have 2 minutes.
5.
You have 2 minutes. You have wasted 5 seconds.
Looking at Article 25 that they are quoting, sub-Article A, despite any other provision of the Constitution, the following rights and fundamental freedom from
Your
torture
Honor,
and cruel.
Your Honor, I wish to object to that line of argument. I addressed the court specifically on Article 25C. In replying, he cannot talk of Article 25A. I will not have a right to reply. Counsel?
Yes. Yes. Your Honor, my point is learned counsel are reading the Constitution selectively. Yes. My point is this. In the same article,
25A?
yes, freedom from torture, cruel, inhuman, degrading treatment. Your Honor, this case is one of the worst cases where a person can be subjected to torture, cruelty, degrading behavior, and what have you. So our point is the article that they are citing is in support of our case. Your Honor, they also say that your orders clearly indicated that they need, that the suspect was entitled to a phone call. You know, that was a matter of choice. The investigators are here, and they're clearly saying he has been given the leeway to make phone calls.
I think what counsel is saying is that he asked to call the advocates and he was denied.
That is an allegation. That is an allegation. I think the court is a better place probably to call the DCIO to come and do what? And explain what transpired. Those are allegations. We're in a court of law. Your Honor, what we are seeking before you is nothing outside our application that was filed before you. Was it on the 5th of September? And as counsel say, we are not before you properly, they are party to those proceedings. Is it selective amnesia? Last time...
Is Ms. Mbani suggesting that Michael should have come to court and just sat there as a proceedings application? Or was he entitled to counsel?
I think what he's saying is plainly that jurisdiction was not challenged.
Yes, and orders were granted.
But you're challenging it now, Your Honor. You can challenge jurisdiction at any point.
That is the law. That is the law. That is the law. Do we agree?
In terms of...
That's the law, that jurisdiction can be attacked at any time?
Yes. Very well. And I'm just responding. I'm just responding. So my point is this, the same order, which is very well drafted, the council came to court before you, they argued their application, and they never challenged the issue to do with jurisdiction. This is in bad faith, Your Honor.
You have 1 minute. What is happening? What is happening?
Your Honor, if I may address also another important issue, what counsel is insinuating, we're trying to drag judiciary into all this. That is not true. There is the common basic principle of separation of arms. Judiciary knows its role. The executive has its role. Within the executive, we have our own structures. We have investigators. We have prosecutors. Judiciary sits on the other side. And because he said we are creatures of the Constitution, that is why we are law-abiding citizens to understand. An accused person must be arraigned in court within 24 hours. And for that, to ensure that he is lawfully held, that is why we were before you. Your Honor, I still insist, because my time is up, humbly, this is a matter of great public interest. Everybody wants to see justice done. We are kindly requesting to allow us to come before you, possibly on Monday, and within that time, we'll give proper direction on how the case will proceed.
Okay, would you want to address me on the issue of disobedience of the court order?
Which is?
Was the suspect, he's not an accused, was the suspect removed to your case on Friday?
Your Honor, the DCIO is here. Probably.
I want you to address me.
You'll give me some time?
Yes.
Is that procedural under? Your Honor.
Because there's an OB, don't make me to call for the OB.
Yes.
Let's be straight.
Yes.
Let us all walk with the line. Was the suspect removed or not?
Yes, he was.
And taken, what time was he removed and where was he taken?
6 a.m.?
Yeah. 6 a.m.
And returned at 7 p.m. in the evening. And Your Honor, if you may allow me.
He was taken from the police station.
Yes.
Which day of the week was that? A Friday?
Friday, Your Honor?
And the court was sitting on that Friday?
Yes.
You agree he was returned at 7 p.m.?
Yes, we do.
How many minutes were the advocates granted to speak to him after he was returned?
As per the court order.
How many minutes were they allowed?
1 hour.
More than 1 hour.
More than 1 hour.
More than 1 hour.
Yes.
You are aware that the court order stated explicitly that counsels were to have access on their client day and night.
Yes, Your Honor.
Mr. Imbali, you agree that the state has already taken a statement from the suspect?
Yes, it was done yesterday.
Yesterday.
Yes, and pursuant to that statement, there are more leads.
How many hours did he stay with the investigators yesterday?
Very long, it is procedural.
I just asked the number of hours. I didn't say it was unprocedural.
From 10 a.m. to 6 p.m. together with the advocates.
Yes, anything else that I need to know, Mr. Mbali?
I believe that should be all. Still, I to answer this time.
Ruling at 1 p.m.
Not obliged, Your Honor.
We retreat, and then for the police, I think it's proper that you ensure that it's convenient for you to move the suspect before you do so. What I find displeasure in is a citizen being pulled and pushed when he's handcuffed. It is not proper that we do that to our own citizens, to our own brothers and sisters. Today it is Oyamo. Let us not set a precedent that tomorrow when I'm arrested, I'm being shoved around while I'm handcuffed. It's inhumane. Unless if you're saying that he's potentially dangerous and he wants to run and he's giving you problems. And if he's giving you problems, let us know that there's a suspect who is giving you problems. But if it's the citizens who are giving you problems, it is within your power to ensure that it's safe enough for you to move this suspect and any other suspect. Let us not have people in cuffs and they are being held by more than 10 people. It is not proper. Let us stop doing that, please. So we adjourn at 1. We will be giving the ruling. So in the meanwhile, we do not have a place to hold him. So I think it would be proper for you to return him to the police station. Mr. Shoya, you have no issues with that? You have no problems? And let the civilians keep off the police station. If you are not an advocate in this matter, that is, you are not representing the suspect. I have not been told that the family has a representative. And if the family has a representative, the representative should not be accessing the suspect, in my own opinion. Is it? Let's hear it from here, so that we do not have pushing and shoving and problems at the police station. So that from here we know that the people who will still access him are the 3 advocates who are on record properly, and then the police will continue accessing him if they still want to interrogate him. And then there was a family member that he decided, he himself appointed to be seeing him. Let's have only that one person at the police station. The rest of the people keep off the place of the OCS, so that we don't have anybody getting injured. And then in that line now, let's have the civilians exit